The Companies Act, there's been much toing and froing on this one. Do we finally have a date in terms of when we'll see implementation on this one?
I wish I could give you a date, Bronwyn, but unfortunately not.
So toing and froing is the right terminology?
Absolutely. As your previous guest said, we're waiting and seeing. And we're also waiting and seeing. DTI indicated that they want to implement a last quarter of this year. We'll wait and see.
The key challenges around the Companies Act, one of the concerns expressed is that you can't bring any new CCs into being. If that terminology is correct, you want to take us through the legalities?
Yes, that's right. CCs won't disappear. We will still have our existing CCs, but from the effective date of the Act, we won't be able to incorporate any new CCs. Existing ones will continue, existing Closed Corporation Act will apply, but no new CCs.
Is the market concerned about the fact that there are going to be no new CCs? I mean, isn't it going to be very expensive for everybody to have to register a private company, and then you've got the onus in terms of auditors and results, et cetera, that you're going to have to spend a lot more time putting together?
Well, yes and no. Of course, our Closed Corporation Act is a very simple act. It's easy for people to follow. If you are a one-man business, it's easy to incorporate a closed corporation and simply have the Closed Corporation Act applying. You don't have directors, you don't have shareholders. You simply have your members of your closed corporation, and they are also the management. In terms of the Closed Corporation Act, of course, as you mentioned, you don't need to be audited. So that is a cost saving, a time saving, an admin saving. Under the new Companies Act, though, if you are a small company, if you're a private company, which a closed corporation, someone who would have incorporated a closed corporation would then instead incorporate a private company. You're not required to be audited anymore unless you comply with certain provisions. So the cost implication of having to be audited, that won't be an issue. But of course, the integris of the Companies Act, the detail of that will now have to be complied with by our closed corporations, or people who would normally have incorporated a closed corporation. I get the comment in many instances where people say, well, let's just incorporate a couple of closed corporations now so that we can use them once the new Companies Act is coming into effect, because we won't be able to incorporate new closed corporations then, for this very reason.
And is this happening? Are you seeing this influx of CCs?
We do see that, yes, but of course you have the limitation that a company can't be a member of a closed corporation. So you can really only do that if you're going to have natural persons being the shareholder.
Mark,
in that context.
You've got a question there.
The current Companies Act incorporates a lot of English legal precedent, and in England they've just recently brought in their new Companies Act. Have we taken quite a bit on board from that?
No, in fact not. Most of the new Act, I would say, is Canadian law, been drafted by Canadian lawyers or have assisted on the drafting. So no, we do not see much of the new Companies Act in the United Kingdom having been incorporated.
Directors' remuneration. Now, Webber Wentzel put out a press release to this effect today, and directors are going to, their remuneration needs to be disclosed across the board, whereas before it was really your executive team.
Yes.
Again, can you take us through the rationale behind this?
Yes. Well, present Act requires directors' remuneration to be disclosed in the annual financial statements, in your audited financial statements. It has to be disclosed in the aggregate. So what we will do is you will say I have 10 directors and the aggregate that I pay to all my directors is X amount. So you don't know individually what they earn. Of course, if it's a listed company, in terms of the listings requirements, you have to disclose the individual remuneration. So that's the one difference between old Act, new Act. But the other difference is that the disclosure in terms of the present Act is really of directors. New Act requires remuneration of directors and prescribed officers. So your chief executive officer, your chief financial officer, your chief operating officer, your legal counsel, and managers of significant parts of your businesses, all their remuneration have to be disclosed, group-wide, whatever they earn from whichever member of the group, and individually.
What's the point?
The point being that you want full disclosure as to each and every director and what each and every one of them earn. At the moment, you don't
like that, Mark.
You don't
I mean, I analyse businesses, and you're living with this forest of detail at the moment that, in fact, it's not necessarily qualitative. It's just adding layer upon layer of numbers that doesn't necessarily improve the understanding. Numbers per se and disclosure is all well and good, but it's got to be appropriate. Mm-hmm. And a lot of financial analysts have specific aspects of a P&L and a balance sheet and cash flow items that they actually look at, and they ignore the rest. And if you want to go digging, well, it's there.
Yes.
Is that any questions from your perspective?
Just maybe on behalf of our bond managers, the bankruptcies and how that the Companies Act will impact that.
Okay, the new provision in the Companies Act. Well, one step back. The present winding up provisions in the present Companies Act will prevail. The new Act does not have any provisions on winding up, except for saying that the old provisions will continue in place. What is different is under the present Act we have judicial management. Under the new Act we have business rescue provisions, which are similar to the Chapter 11 bankruptcy provisions in the United States. What is different, once again, from that is, however, that under the new Act, a board can simply pass a resolution and put a company under business rescue, with the far-reaching consequences of going into business rescue following from that without any court oversight.